going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a weird one. That's all I can call this, a weird one. Uh, Mild trigger warning. This is gross. It really is. It's a landlord tenant case. Luckily, the tenants have someone arguing for them. They do have an attorney. I think it might be legal aid. This is weird. I don't really have any other words for this. So just watch it. Let me know how you feel in the comments. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kickback lifts. Let's go.
Boardman Lake. Ms. Clody is here for the Levines. Did I see the Levines anywhere? Yes. So let's see. So I just want to confirm that is Dayton and Christy Levine. Is that correct?
Correct, Your Honor.
All right.
Yes.
Good. All right.
Well,
Okay. So I've read the motion here. I might have misstated this. It's a motion for summary disposition by the Levines, and Ms. Clody is here for that. So I've been through the motion. Ms. Clody, any argument you'd like to make in addition to your motion?
Yes, Your Honor. I just wanted to point out here, there are two main issues raised by plaintiff. The first is that, defendants willfully or negligently caused a serious and continuing health hazard to exist. And they further allege that defendants have repeatedly violated their lease. And before I kind of delve into the particular circumstances of that, I'd like to point out that the most important fact for purposes of this motion is that before being summoned to court, defendants received a 7-day demand for possession for a continuing and serious health hazard, as opposed to a 30-day notice to quit for repeated lease violations. And that is particularly relevant because in order for that 7-day demand for possession to be sufficient notice under the law, plaintiff must be able to establish that not only did this defendants willfully or negligently cause a serious and continuing health hazard, but also that upon receipt of that demand that they did not substantially repair or restore the premises. And I believe that even with the current facts as provided in plaintiff's response brief, that you should find that plaintiff has not met his burden and defendants did substantially restore or repair the premises. In your motion, in our motion, we have we've provided the last lease violation notice that defendants received claiming unsanitary conditions, which is objectively very broad. But once defendants received this notice, they did, tidy the apartment. You'll notice in the pictures we've provided that the surfaces are clean, the clutter's been cleared. And, plaintiff does mention that to the court that the apartment has an odor. And of course, those claims are disputed, but I'd like to point out that smell alone cannot necessitate a serious and continuing health and safety violation, even if they could substantiate that it was originated from defendant's apartment, which I believe they cannot. We're not talking about a toxic gas here. We're talking about an odor that they claim to have dealt with for many years prior. Plaintiff also provided to the court visibly dated pictures, and we know that mostly because they picture defendant's cat, who has been deceased for nearly 2 months. I think the court should take that into consideration. I do believe as a matter of law, that plaintiff's claim for possession based on a continuing and serious health hazard should be dismissed. Also that in plaintiff's brief in response, they do seem to focus predominantly on repeated lease violations. But if plaintiff's claim for a continuing and serious health hazard is dismissed, then defendants have received improper notice because they've only received 7 days. It is undisputed that defendants pay a monthly rent under a lease agreement, so they should have received a 30-day notice to quit. And, the true purpose of this motion today, at its heart is that, plaintiff seems to be only alleging a continuing and serious health hazard to shorten the notice period for what is functionally a claim for possession due to repeated lease violations. So I believe that the court should dismiss plaintiff's claim to prevent, because if the court upholds this behavior, then any landlord would allege a continuing serious health violation to shorten that notice period. So I would ask that this action be dismissed. Thank you.
Mr. Popovits?
Thank you, Your Honor. I don't have a whole lot to add to our brief. This is not, there's a mischaracterization of the underlying intention of the 7-day notice. Boardman Lake is a complex that doesn't take eviction lightly. Its purpose is not to evict people, but to provide affordable housing. So when an opportunity comes, it's one that's taken under great consideration with respect to what notice would be given. Only in the most extreme circumstances, this being such, would a 7-day notice of health hazard be issued. And it's not as if the issue had just immediately arose, the notice was given, and we're fast tracking some issue that could otherwise have been clarified. Boardman Lake has been worked, as is evidenced, I believe, by the affidavit of Lori Ebright that was submitted with the response, has been working with these folks for a continued and prolonged period of time. These folks have been enrolled in the adult protective services because of the condition of their apartment. I find it a little concerning, actually, by opposing counsel to be so dismissive of the condition for which this apartment is and continues to be in. And it wasn't a situation that could be resolved through tidying up. We've actually asked for a counter motion for summary disposition for possession to be granted in plaintiff's favor today, given the facts and the affidavit supported by Ms. Ebright. I think it would be extremely premature, however, to rule in favor dispositively in defendant's favor to dismiss the case based on the arguments that are made that there was tidying up. This is a very serious situation, and one that's not taken lightly by Boardman Lake as to the health and the safety of these tenants and the tenants around, given the condition of this property. We've outlined all of that in the response. We know Your Honor has read the response. There's photos. One of the reasons that the photos aren't more current is quarterly inspections are being refused. Why would quarterly inspections be refused if the apartment was in a condition that would substantiate or negate the need for this notice? So with that being said, Your Honor, we would, as set forth in our brief, request that a judgment for possession be entered under counter motion for summary disposition court rules as outlined in the brief, but certainly that the motion for summary disposition be denied, in this case progress to a formal hearing concerning the situations where these folks could better present their defense, but more importantly, where plaintiff can present Ms. Ebright's testimony, the testimony of maintenance folks, the testimony of adult protective services.
Yeah.
All of these items are necessary for this court to make a informed ruling, I believe, as to any potential dismissal of this very serious situation.
So I have to agree with that. The facts are, I mean, they're going back and forth between each side. There's clearly a factual issue here. I don't want to decide this without having the testimony of everybody involved because it is such a serious issue. So I'm going to deny the motion for summary disposition and deny the counter motion too, and we'll set this for a hearing, a trial as soon as we can. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Yep, we're all set. So thank you.
All right. I cannot wait for this trial. This is interesting. I mean, I think everyone can see both sides of this. The attorney for the tenants, I always want to say defense attorney, and I don't know if tenants are technically defendants. I don't know. Probably, but so I try to stay away from words like that. But he did a great job getting this thrown out. I mean, his motion wasn't granted. Both motions were thrown out, but good job to him. And it just sounds like these tenants are people that you don't want to live next door to. I'm sorry. These allegations wouldn't be allegations if there wasn't some sort of truth to them. Even if they're only 50% true, doesn't sound good. All right. Video. If you haven't done it already and you did enjoy the video, please hit that like button. I would appreciate it. I am mumbling now, stumbling over my words, talking in circles. That means I need to let it go. Until next time,
Everybody, feel free to sign out.
Thank you, Lori.